The order appointing a special fiduciary or suspending the powers of a fiduciary. Hey, I'm Darren Findling of the Probate Pro. We're going to examine Scale Form PC 602. Scale for State Court Administrative Office, PC for Probate Court, Form 602. This is a form that you generally wouldn't prepare, but rather you'd receive it as an interested person within the estate. Maybe you're the fiduciary, maybe you're an interested party in the affairs of a probate administration, and the court generally would issue this particular order that triggers a suspension of the fiduciary, a notice that the fiduciary has failed to perform certain responsibilities, and maybe the appointment of a special fiduciary to handle the particular roles. A fiduciary is a person appointed on behalf of another to be responsible for those affairs and to look out for that individual beyond and above their own interests. So a fiduciary can be a personal representative, a trustee, guardian, conservator, etc. All of these scale forms are created or give rise by virtue of various statutes and court rules. In this case, Court Rule MCR 5.203D and 5.204, which reference the statute MCL 700.1309. That statute provides that the court, on its own initiative with information from a third party or from the file itself, can suspend a fiduciary who is performing a particular role and can also appoint a special fiduciary, a person to come in to perform a particular role. It may be for a limited time frame or it may be broader. So, for example, if somebody is serving as a personal representative and they have failed to do an inventory or account, the court can suspend that fiduciary and also appoint a special fiduciary to come in and solve the problem, fix the issue, and maybe for that limited purpose, or file a request to then remove the current personal representative. So let's work our way through the form itself to understand what's going on here. In the top left corner, referenced in the blue rectangle, is the county in which the matter exists, and the top right corner is the case number. Pretty basic information there. In the red rectangle, you'll see that there's a checkbox for whether the order is to appoint a special fiduciary or to suspend the powers of a fiduciary. So often both of those boxes are checked, or of course one or the other could be. Then the estate of, in the matter of, this is the name of the person upon which the matter is existing. So for example, the estate of John Doe, or in the matter of John Doe. The date of the entry of the court order and the judge, and the bar number, which is the professional number of that judge. And then the findings of the court. In this particular case, the court has found that the fiduciary, maybe it's the personal representative, trustee, guardian, conservator, etc., has failed to do something. And then there's nice little checkboxes here to address those most commonly forgotten to be performed. Failed to file an inventory, failed to file an account, failed to file a report of guardian on condition of war. This would, of course, be in a guardianship context. Failed to file a notice of continued administration, which is in a deceased estate, or the papers that are required to close the estate in a deceased estate proceeding. And then there's a little checkbox with a line. So there is some opportunity for the court to suspend fiduciary as well as appoint a special fiduciary for other reasonings. Now, as you can see, some of those items relate to a deceased estate, some to a trust administration, some to a guardianship and conservatorship. So this form has wide use. Section 3, a checkbox for prompt and proper administration of the estate requires the appointment of a special. So again, if that top box at the top of the page is checked, this is the provision that says that there is a need for prompt and proper administration, and that there's a need for the appointment of a special fiduciary to come in and perform a very particular role. Maybe it is the failure to file the inventory, for example. So the special fiduciary may get appointed to be assured that an inventory gets appropriately filed. And again, there's a little bit of room there for the court to identify the basis or the reasoning for the appointment of the special fiduciary. This is part of its finding, but of course it's not limited to simply that little one line, that little one underlined section there. 4, there's no qualified suitable individual willing to act as a special fiduciary, and the appointment of a professional guardian or conservator as special fiduciary is in the best interest of the ward, and a bond must be filed. So what 4 is referring to is that only in a guardianship and conservatorship context, the court has to make a finding before appointing a professional fiduciary to come in and serve as a professional guardian and or conservator. The court first must find that there are no other family members, no other people within the interested party list that are qualified or suitable to serve in that role. So the court must make a finding that there's nobody else suitable and qualified to serve in that role before they go and appoint a special fiduciary who is a professional guardian. So for example, an agency or an attorney or somebody appointed through the court system outside of the family. And then, as you can see, it is a requirement that if a special fiduciary is appointed, then a bond must be filed as part of that to guarantee, to be assured that they perform their role accordingly. The next section is the order section. So above are the findings of the court, and now it is really the meat and potatoes here. The essence of this is the order of the court. This is what the court is ordering to occur. 5, the powers of the fiduciary are suspended. So if there is a suspension and or removal and or appointment of a special fiduciary, the court can check box 5 and say that the powers of the existing fiduciary are suspended. 6, the identification of who's getting appointed special fiduciary and whether there's a need for a bond to qualify or the filing of an acceptance of appointment. And within that special fiduciary appointment, the court can identify the limitation of powers or the expansion of powers. So the court could simply say with no restriction, or the court could say for the purpose of filing a notice of continued administration, or for the purpose of investigating this particular issue. The court can limit or expand the powers. The next box says a petition to remove the fiduciary has not been filed, and the special fiduciary should file the petition. So imagine if the court believes that the special fiduciary needs to be appointed and the existing fiduciary, not only that their powers should be suspended, but their powers should be terminated and they should be removed in their role as guardian, conservator, personal representative, or trustee. That box provides that the special fiduciary has the additional responsibility to now file a petition to remove that fiduciary from their role. Section 7 is this discussion we had a little bit earlier about there's no available person to serve, so the powers of that person are suspended until further order of the court, and there can be a petition for the removal of the fiduciary and appointment of a successor, and or whether the estate administration is closed. So for example, the court can simply say in a deceased estate, we're going to close the estate administration. So just kind of bring a closure to the deceased estate without the formality of closing it with a sworn statement to close or a petition and order for complete estate settlement. Again, a lot going on here. And with all of these scale forms, we urge you to be working with a skilled, competent probate lawyer to avoid having powers suspended, to avoid having a special fiduciary appointed and incurring both the headache around it and the cost and the exposure, liability that goes with these types of issues. Section 8, within 28 days of the suspended fiduciary shall file an account. So imagine the suspended fiduciary is now being ordered to account to the court for their actions and affairs, and there should be a requirement to serve. So again, a lot of options for the court to reference here, and the court can trigger this order for suspension of fiduciary and appointment of a special fiduciary based on its own review of the court file. It may be on a petition, it may be on information that is learned. We've seen this situation occur when a fiduciary, they're learned that the fiduciary is incarcerated or has died. or has gone ill, and there's a triggering of events that may take place. Those are just some examples here of the various times that a fiduciary may be able to, may be not completing their responsibilities, but they also may be breaching their fiduciary duties, violating the statute and doing things incorrectly that could trigger also the appointment of a special fiduciary and the suspension of their powers. Now, you have the right as an interested person in an estate to always file a petition to remove a fiduciary. There's various forms to do such a thing, as well as to hold them accountable by requiring them to account, or to argue that they've breached their fiduciary duties and ask for them to be surcharged. Those are other petitions that you can proceed on if the fiduciary has failed to perform their role. But this particular form, PC 602, is generally triggered by the court, usually when somebody has failed after they've been notified that they're late on their inventory, account, report of guardian, or notice of continued administration. That's why those little checkboxes exist at the top of the page. These are often triggered by virtue of the court just simply looking in its court file and identifying that there is a deficiency. The deficiency was not cured or corrected timely, and then the court moves forward to appoint a special fiduciary. At the Probate Pro, we are passionate about everything probate. If you have questions about this particular form or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.